You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The confidentiality of substance use disorder treatment records is governed by a specialized regime under Title 42 of the Code of Federal Regulations, Part 2. This framework predates HIPAA and was developed to address the particularly sensitive nature of addiction treatment. The fear of stigma, discrimination, or even criminal exposure has historically deterred individuals from seeking help. Recognizing this, Congress established Part 2 to provide heightened confidentiality protections beyond what HIPAA alone requires. For learners, this rule demonstrates how the legal system adapts to the unique vulnerabilities of certain patient populations. While health data is sensitive in general, substance use disorder records carry risks that can affect employment, housing, legal status, and personal dignity, making rigorous protections essential to encourage treatment and recovery. Part 2 applies specifically to federally assisted substance use disorder treatment programs and their personnel. This includes programs that receive federal funding, hold federal tax-exempt status, or are licensed or certified by the federal government. Even programs that refer patients to federally funded entities may fall under its scope. For learners, the applicability highlights how confidentiality protections extend broadly across the addiction treatment ecosystem, not only to large hospitals, but also to community clinics and specialized programs. The inclusion of staff and contractors ensures that protections travel with the records, no matter who is handling them. Understanding applicability is crucial, since obligations under Part 2 can differ significantly from general HIPAA compliance. The scope of patient-identifying information under Part 2 is also broad. It includes any details that would directly or indirectly identify an individual as having a substance use disorder, receiving treatment, or being referred for treatment. This encompasses diagnoses, treatment notes, and referral information, but also contextual data such as program enrollment or attendance at therapy sessions. For learners, this wide scope reflects the heightened sensitivity of association itself. Unlike other medical contexts, simply being linked to an addiction treatment program may expose a patient to social or legal risks. Protecting identity, therefore, is as important as protecting the content of medical records. The general rule of Part 2 is that disclosures cannot occur without the patient's specific written consent. Unlike HIPAA, which allows numerous uses and disclosures without authorization, Part 2 places patient choice at the center of data sharing. This consent requirement ensures that patients retain meaningful control over who knows about their treatment. For learners, this highlights the consent-centric nature of Part 2. It demonstrates a deliberate policy decision, empowering patients to decide whether disclosure serves their best interests, recognizing the potential consequences of unwanted exposure in contexts such as employment, law enforcement, or community standing. Consent under Part 2 must contain specific content elements to be valid. These include the name of the program permitted to make the disclosure, the recipient of the information, the purpose of the disclosure, the information to be shared, and an expiration date or event. Without these details, the consent is not sufficient. For learners, this specificity highlights the rigor of Part 2 compared to HIPAA. Vague, blanket authorizations are not allowed. Instead, consent must be narrowly tailored, ensuring that patients fully understand the scope of what they are permitting. This requirement reinforces the principle that disclosure of substance use disorder information should never be casual or open-ended. A unique feature of Part 2 is the redisclosure prohibition notice. When Part 2 information is shared with authorized recipients, it must be accompanied by a statement forbidding further disclosure unless expressly permitted. This ensures that confidentiality protections travel with the data, preventing it from being freely reshared once it leaves the original program. For learners, this illustrates how Part 2 addresses the risks of secondary use. Without redisclosure limits, sensitive information could quickly spread beyond the patient's intended audience. undermining the very protections Part 2 was designed to provide. It creates a legally enforceable boundary around the information even after initial disclosure. Part 2 does allow limited disclosures without consent in cases of medical emergency. If a patient faces an immediate threat to health or safety, information may be shared with medical personnel to ensure appropriate treatment. These disclosures must be documented, including the nature of the emergency and the recipient. For learners, the emergency exception demonstrates a balance between privacy and safety. While confidentiality is paramount, it cannot be absolute when life or health is at stake. This narrow exception allows necessary care without opening the door to broader disclosures. It embodies the ethical principle of prioritizing immediate patient welfare while preserving confidentiality in ordinary circumstances. Research disclosures are permitted under Part 2, but only with strict safeguards. Qualified researchers may access information if approved by an institutional review board or other oversight body, and data must be handled in ways that protect patient confidentiality. Identifiers may be limited or removed where possible. For learners, this shows how Part 2 balances societal interests in advancing knowledge with the individual's right to privacy. Research can drive better treatments and outcomes, but it must not compromise the trust that patients place in treatment programs. This provision illustrates how confidentiality can coexist with innovation when proper safeguards are in place. Audit and evaluation disclosures are also permitted under Part 2. These allow qualified persons, such as regulators, payers, or oversight bodies, to review program performance, compliance, and quality. However, such disclosures are strictly limited to purposes of oversight and cannot be repurposed for law enforcement or unrelated activities. For learners, this demonstrates how Part 2 maintains accountability without undermining patient privacy. Audits and evaluations are necessary for program improvement and compliance, but they are tightly bounded to prevent misuse. This balance reflects the dual goals of transparency in operations and protection of patient confidentiality. Disclosures under court order are possible, but tightly constrained. Judges may authorize disclosure of Part 2 information only under strict criteria, such as demonstrating good cause and considering alternatives. The court must weigh the public interest and potential harm to the patient, and orders are typically narrow in scope. For learners, the court order pathway highlights how Part 2 treats legal demands differently from ordinary HIPAA cases. While subpoenas often suffice under HIPAA, Part 2 demands judicial scrutiny and protective procedures. This reflects the recognition that exposing substance use disorder records carries risks that must be carefully balanced by the courts. Part 2 does not override obligations to report child abuse or neglect. Programs must still comply with state laws requiring reporting of suspected abuse, even when substance use disorder records are involved. For learners, this illustrates how Part 2 balances confidentiality with broader public policy goals. Protecting children from harm is treated as paramount, and confidentiality cannot be used as a shield against reporting obligations. This carve-out ensures that patient privacy does not come at the expense of child welfare. Another exception involves crimes on program premises or against program personnel. Programs may disclose information about such incidents to law enforcement, but disclosures must be limited to the circumstances of the crime. For example, a program could report an assault on staff but could not disclose unrelated treatment details. For learners, this exception demonstrates the practical need to balance confidentiality with safety in the treatment environment. Staff and patients alike require protection, and limited disclosures ensure that programs remain safe without eroding overall confidentiality guarantees. De-identification provides a mechanism for using Part 2 data without compromising privacy. Programs may strip identifying details to create anonymized datasets for analysis, reporting, or operational purposes. De-identified data falls outside the scope of Part 2, provided that re-identification risk is minimal. For learners, this reflects a consistent theme across privacy law. Data can be valuable for oversight, research, and improvement, even without personal identifiers. De-identification allows programs to contribute to broader knowledge while safeguarding individual confidentiality. Segmentation challenges arise when integrating Part 2 data into electronic health records. Unlike HIPAA data, Part 2 records must often be tagged and segregated to prevent unauthorized access or disclosure. This creates technical and operational complexity, especially when systems are designed for interoperability. For learners, segmentation illustrates how heightened confidentiality can strain digital infrastructure. Balancing data integration for coordinated care with the strict limits of Part 2 requires sophisticated system design, often leading to parallel workflows or specialized tagging mechanisms. These challenges reflect the friction between modern interoperability goals and legacy confidentiality protections. Finally, coordination of care presents ongoing complexities under Part 2. Sharing substance use disorder information across providers and payers can improve treatment outcomes, but it must be done within the confines of consent and redisclosure restrictions. For learners, this demonstrates the tension between privacy and integration. While coordinated care is essential for holistic treatment, Part 2 ensures that patient control and confidentiality are never sacrificed in the process. This delicate balance remains one of the most debated aspects of health data governance, highlighting the unique role of Part 2 in protecting vulnerable populations while enabling effective care. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Once consent is withdrawn, programs must immediately cease further disclosures, though information already released may remain with authorized recipients, subject to redisclosure restrictions. This ensures patients retain ongoing control over their treatment information, reflecting the principle that consent is not permanent but conditional on continued agreement. For learners, revocation emphasizes patient autonomy in one of the most sensitive areas of health law. It provides a safeguard against regret or changing circumstances, reassuring patients that they can limit sharing if they later feel uncomfortable or endangered. The right to revoke is not symbolic. It is a functional tool to preserve trust and encourage honest participation in treatment programs. Accounting and record-keeping duties are another core feature of Part 2 compliance. Programs must maintain documentation of disclosures, including the legal basis, recipient, and scope of information shared. This log becomes critical during audits or investigations, demonstrating that the program adhered to regulatory standards. For learners, these obligations illustrate how transparency supports accountability. Without clear records, programs cannot prove compliance, nor can patients track how their data has been used. Record-keeping is not merely administrative. It is a cornerstone of trust and governance in environments where misuse of information can carry life-changing consequences for patients. To protect against unauthorized viewing or extraction, Part 2 requires security and access controls tailored to the sensitivity of substance use disorder records. This includes role-based access, authentication measures, and system configurations that segregate Part 2 data from general health records. For learners, this reinforces how privacy protections must be operationalized through technical safeguards. Policies alone cannot stop inappropriate access. Systems must be designed to prevent it. Access controls demonstrate how Part 2 goes beyond rhetoric to demand tangible, enforceable protections that match the heightened risks of disclosure. Training and policy development are critical for staff working in Part 2 programs. Employees must be educated about the unique restrictions and obligations, including the prohibition on redisclosure, the requirements for consent, and the narrow scope of exceptions. Policies must be documented and regularly updated to reflect evolving guidance. For learners, training highlights how compliance is a cultural and organizational practice, not just a legal mandate. Staff who interact daily with patients and data are the first line of defense against violations. Without ongoing training, even well-crafted policies can fail in practice. Business associates and contractors also bear responsibilities under Part 2. When third parties handle substance use disorder information for billing, analytics, or technical services. They must adhere to the same confidentiality rules as the programs themselves. Contracts must reflect these obligations, ensuring downstream compliance. For learners, this illustrates the principle of shared accountability. Privacy protections lose, meaning if vendors can operate outside the rules, by extending obligations beyond direct providers, Part 2 ensures that confidentiality safeguards remain intact across the service chain. The interplay between Part 2 and HIPAA often creates confusion. While HIPAA provides a broad framework for privacy, Part 2 imposes stricter requirements in specific contexts. For example, HIPAA permits disclosures for treatment without consent, while Part 2 generally requires explicit patient authorization. For learners, this comparison reveals how different legal regimes coexist. Where both apply, the stricter rule governs, meaning programs must carefully evaluate which framework controls in a given situation. Understanding these differences is essential for avoiding violations while enabling appropriate care. Law enforcement requests for Part 2 data must be handled with caution. Unlike general medical records, substance use disorder records cannot be released on the basis of ordinary subpoenas. Verification of authority, judicial review, and minimization of disclosure are required. For learners, this highlights Part 2's strong stance on protecting patients from legal jeopardy. The system is designed to resist easy access by law enforcement, treating confidentiality almost like a privilege. This protects patients from being deterred from seeking treatment out of fear their records could be used against them. Litigation discovery presents similar challenges. Programs may face requests for records in civil proceedings, but Part 2 requires courts to apply strict criteria before ordering disclosure. This resistance to discovery further underscores the privilege-like status of these records. For learners, this demonstrates how Part 2 creates legal friction, ensuring that disclosure is truly necessary and justified before sensitive data is exposed. It is a protective barrier that balances judicial needs with the patient's right to confidentiality. Breach response under Part 2 carries heightened importance. Although breach notification requirements are governed by HIPAA for many programs, Part 2 records require special sensitivity due to the potential for stigma and legal consequences. Programs must evaluate incidents not only through the lens of compliance, but also through the ethical duty to protect patient trust. For learners, this highlights how breach response must be tailored to context. The reputational and personal risks tied to Part 2 data amplify the stakes of mishandling, demanding particularly careful communication and mitigation. Patients retain rights to inspect and receive copies of their Part 2 records, subject to applicable program policies and legal requirements. This access empowers individuals to review their treatment history, monitor accuracy, and participate actively in their care. For learners, this provision emphasizes patient empowerment as a cornerstone of privacy law. Even in a confidentiality-heavy regime, individuals are not shut out of their own data. Instead, they are given tools to engage with their records in a manner consistent with recovery and accountability. Cross-state data exchanges create additional complexity. Some states impose stricter confidentiality laws or additional permissions, while others align closely with federal rules. Programs operating across jurisdictions must reconcile overlapping requirements, often applying the most protective standard to avoid violations. For learners, this illustrates the layered nature of privacy law in the United States. Compliance is not only about federal rules, but also about harmonizing them with state frameworks, ensuring protections remain intact across boundaries. To support compliance, programs often rely on documentation templates for key processes. Standardized forms for consent, emergency disclosures, and court orders ensure consistency and reduce the risk of error. For learners, these templates illustrate how operational tools bring legal mandates into daily practice. By structuring disclosures through approved forms, programs reduce ambiguity and enforce discipline in handling sensitive data. Templates are not just paperwork. They are safeguards against accidental non-compliance. Governance metrics help programs monitor their compliance posture. Tracking incidents, training completion rates, and access audits provides insight into where improvements are needed. For learners, metrics demonstrate how compliance is measured and managed over time. Numbers provide clarity about performance, enabling leaders to focus resources on areas of risk. Governance thus shifts from reactive problem-solving to proactive oversight, ensuring Part 2 protections are consistently applied. Finally, programmatic review cycles ensure that policies and controls evolve alongside guidance, technology, and treatment models. As electronic health records expand, as new federal interpretations emerge, and as patient needs shift, programs must revisit their safeguards. For learners, review cycles underscore that compliance is not static. Confidentiality protections must adapt to remain effective, especially in dynamic digital and regulatory environments. Part 2's emphasis on continuous review ensures that its protections remain relevant, practical, and enforceable in a rapidly changing healthcare landscape. In conclusion, 42 CFR Part 2 creates a consent-centric confidentiality regime that places extraordinary emphasis on patient control, redisclosure limits, and rigorous operational safeguards. By combining rights of access and revocation with strong restrictions on law enforcement and litigation disclosures, it builds a framework that protects patients from stigma and harm while supporting effective treatment. For learners, the lesson is that privacy law evolves to meet the needs of vulnerable populations. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.